So if people have tried to solve the problem themselves and they've failed and they've gone to their lawyers and the lawyers haven't been able to find a friendly solution, then we have to do something official about it. And there are quite a number of ways of doing that, aren't there? There's mediation, there's arbitration, there's going to court, and so on. Let's deal first of all with mediation. Is mediation common in Spain?
It is common in Spain in some cases, okay, before going to the court. Okay?
So it's seen as a step before going to court rather than a complete alternative to going to court.
That is. But mediation is a system that in Spain, mediation can be done if both parties are agree with doing that mediation. Okay?
Now let's just explain for the benefit of the viewers, some of them may not be familiar with mediation, that mediation is really where the two people in a dispute agree that they will appoint a third person, usually a qualified mediator or a lawyer, and that person's job is not to represent either, say, the buyer or the seller. It is to help them find a middle way and to find a compromise. So with mediation, you do not have a winner or a loser, you have a compromise solution.
That is.
I think most lawyers in every country would agree that generally going to court is always a bad idea. I mean, if you can do anything to avoid going to court, it's to be sought.
It will be good.
And mediation is one way of doing that. But
mediation,
But it's for ordinary disputes in Spain, not that common.
No.
Now, what about arbitration?
Arbitration is a way to get a solution that is more common in Spain.
Yes.
Okay? And every year is more common to go to an arbitration.
Now, again, for the benefit of viewers who are not familiar with this, arbitration is where you go to, it's effectively like going to court, but you're going to a judge who is not a member of the court system. It's almost like a private justice system.
Arbitration is a system in which one independent person, normally a lawyer, is going to decide about the problem.
Yes.
Okay. But the difference between the mediation and the arbitration is that with the mediation you have no obligation to accept the decision that has been made by the third party.
Yes.
With the arbitration, you must accept the resolution that has been done by that third party.
So you've authorized that person, just like going to court, you've authorized that person to make a binding decision.
That is. Yes. And the decision that third party is going to make with an arbitration is the equivalent of a judgment.
Yes.
Okay.
And in most cases, you will then have a right of appeal against that arbitration if you wish to do so.
Yeah.
Now, the important thing about arbitration, though, isn't it, is that, again, you have to agree to it.
Yeah.
So either in your contract, it will say that if there's a dispute, this should be solved by arbitration, or if it doesn't say that, then the two parties must say, well, let's try and solve this by arbitration rather than going to court.
That is, it is that we can be in an arbitration because in the contract that we have signed is doing mention that any dispute will be solved through the arbitration system. Okay, the arbitration system is very regulated in Spain. We have a specific law from 2003 regulating that, and it can happen because there is nothing in the writing that we did, but both parties decide to go to the arbitration system.
Yes.
Maybe because it's cheaper, because it's quicker, and both parties agree to do that. That is when the arbitration arises.
And I think those are the two words, aren't they? Cheaper and quicker. That's why people go to arbitration rather than going to court.
Mainly, yes.
Yes.
Yeah.
And I think some people would also say that maybe you have more chance of salvaging your relationship if you go to arbitration. It is a slightly cooperative approach. So if you and the other party agree to go to arbitration, maybe he can remain your customer after the dispute is dealt with.
That is correct. And how the arbitration is going to happen is going to be in a more informal way than the court case. Okay.
Yes.
The arbitrator is going to have a meeting with each part. Is going to analyze the documentation, that the evidence that each part has to defend their position, but all that is going to happen in a more informal way than in a court case through a trade.
Now, if you're dealing with an arbitration, sometimes people do arbitrations without lawyers, and sometimes they use lawyers to interact with the arbitrator. Which do you find more common here in Spain?
More common is to do the arbitration through the lawyer.
Yes.
Okay, it is that the lawyer is going to be involved with you in that arbitration system.
Because the lawyer has to do exactly the same things as he would in court, and that is to say, gather all of the evidence together, present it in a way that the arbitrator will understand, and then maybe explain clearly and persuasively why your version of the events is better than the version given by the other side.
That is very similar, okay, in a more informal way, but it's very similar than when you have a court case.
Yes.
You must prepare in writing what is your position, what documentation you have to defend your position, and everything is very similar than in a court case. It is that you need a lawyer for that, because at the end of the day it's going to be a specific lawyer, okay, and a specific third party who is going to make that decision. It is that you are well advised from the beginning in order to have a good resolution, because at the end, that resolution that in Spain is called laudo, okay, is the resolution that is going to put an end to the dispute.
Now, you've said that in Spain the way in which arbitration has to be conducted is closely regulated by law. So you're going into something which you know is controlled. Roughly, and I know obviously this varies enormously from case to case, but roughly how long would you expect a simple dispute to take to be dealt with through an arbitration?
Through an arbitration, a simple dispute can be resolved in 2 months, 3 months.
And if you were instead to go through the court system, how long would it take?
More than a year.
Yes.
More than a year.
And then we'll come back to this, but then at the end of that year, it's very likely that one of the parties would appeal the decision, and then you've got another year.
And it happens in the 60% of cases that one part of the order is going to appeal to a second instance.
So really, arbitration can be a great deal quicker and therefore a great deal cheaper.
Quicker and cheaper way to get a result.
Do you recommend arbitration to lots of clients?
I recommend arbitration. And when I recommend the arbitration, but it's good to know that when you are appointing in the contract that the arbitration will be done, it is good to mention who is going to do the arbitration.
Exactly.
Okay? It is that if the institution that is going to appoint the lawyer, the professional, the person who is going to the arbitration is very important. Okay? In Spain, it's very usual that we do mention in the contract that the college of lawyers, like a bar association, will appoint the specific lawyer for the arbitration. Okay? It is that if you see that in the contract there is mentioned that arbitration, check who is going to do the arbitration before signing the contract.
So, going back to this idea of avoiding problems, if you're thinking of having a contract drawn up, think about arbitration. It's not always best. Sometimes you can think court is best, but it should be thought about when you're preparing a contract whether you're going to get disputes resolved by arbitration or by going to court.
That is.
Okay, excellent. And so if we don't go the arbitration route, either because the contract didn't say that was the way it must be dealt with or because the parties won't agree, then of course we have to go to court.
And then we go to the court. Okay.
How do you start a court case?
Court case can be started directly by one of the parties. Okay, it is that in Spain there is no obligation to do a letter, a preliminary letter to the other part informing about that you are starting a court case.
Now that's important because in many countries that is an absolutely essential first step. But in Spain that's not the case.
In Spain it's not necessary to produce that letter before going to the court. It is advisable to do it. Okay, it is that in all cases we do it. Okay,
and if you don't do it, Are you at risk that if you win the case, the court may not order you to receive your costs, for example, paid?
No, that is not the point of it.
It's not an issue there. So it's just a question. It's better practice to write a letter warning people.
Better practice in order to try to get a solution.
A last-minute solution.
The last-minute solution before going to the court.
Yes.
It is a common practice. That is what we do, is that normally we send a letter to the other part stating that in 15 days we are starting the court case, just if it is possible, a mediation between the lawyers in order to get a solution before submitting the demand on the court.
Yes.
Yes.